On August 10th, shortly after midnight, the prosecutor's right. Garrison Hester was shot. On August 10th, shortly after midnight, the prosecutor is right. He was shot and robbed of his gun that he used to work as a security officer. On August 10th, shortly after midnight, the prosecutor, though, is very wrong about one thing. Steve Shores didn't shoot him. Steve Shores didn't rob him. Steve Shores is innocent. In order to understand this case, I want to sort of take you on a trip, and you'll hear evidence about this as the case goes on, to see what this neighborhood was like. Maybe some of you know about it, maybe some of you don't. But it's changed a lot in the last few years. But in this time, 39th and Drexel was quite a place. It's a big, wide street. There are 2 lanes of traffic and a lane for parking. There's a grassy midway, which is at least 2 lanes wide. And on the other side, on the east side, it runs north and south. On the east side, there are 2 lanes for traffic and a lane for parking. It's a very, very big, wide street. And a long time ago, it was an elegant, beautiful street. A long time ago, and you can still see it, there were beautiful, gracious homes with beautiful gray flagstone and lovely steps that curved with statues on the front. But that neighborhood changed. That's the word we use. That neighborhood changed and became poorer and became more desperate. And then it became the property of, the territory of, the place where a gang ran everything. Perhaps you've heard of the gang. And you're going to hear about this throughout the trial, although perhaps the prosecutor wishes you wouldn't. This gang is called the El Rukins. They used to be called something else. They were the gangster something or others. Then they decided to pretend that they were a religion of some kind. And they bought, among other things, the building on the corner of 39th and Drexel. And they call it a mosque, which is just, the evidence will show, sacrilegious, frankly. And they have their gang meetings there, and that's where the top guy, lives on the top floor. And they run the neighborhood. The evidence will show they run the neighborhood. And this is so important as you consider this case. So important. They run the neighborhood. People are terrified to say anything about anything they see. And this is important. And you need to listen to the evidence on this case because you need to understand why Steve Shores saw what he saw, did what he did, and remained silent. You see, that night, Steve Shores, who is just a guy who happens to live in a rotten neighborhood, he's not a constitutional scholar or anything. He's just a guy. He works at Kokomo Meats. He packages meat, and sometimes he drives a delivery truck, and he graduated high school, and he lives with his mother and his sisters, and he helps support him, and he's just a guy who lives in a bad neighborhood. A bad, gang-dominated neighborhood. And that particular night, he and his friend Robert were riding their bicycles down 39th on the west side of the street. Remember, the killing happened on the east side of the street. On the west side of the street, on their way to 40th Street, which is where Steve lived. They'd been down by the lake. It was a warm night. And as they were riding their bikes, Steve heard a shot, looked to his left, saw a man over another man fumbling with something, saw that man get up, join up with a second man, run across the midway, right in front of his bicycle, and unfortunately, the man who had been going through the man's pockets, through Mr. Hester's pockets, looked up as he ran across and saw Steve's face framed under the light of a streetlight that's right there by the corner. And he knew him. I don't mean he was friends with him. I mean, he lived in the neighborhood. Everybody knew everybody. And he saw him. You will hear about the investigation in this case. You will hear how many people were picked up in this case, including that man, David Bo Burns, and his friend, Chester Blood Bland, and how they were interrogated at the police department, and how they named Steve Shores as the killer. And they will come into court and they will tell you that actually they are friends with Steve Shores, a guy with a job. That actually they are buddies, that they hang out together, and that for some inexplicable reason they were hanging on the west side of 40th Street and drinking and whatever. And Steve says, I feel like shooting that chump over there. Ran across the street for no particular reason and shot someone. That's what they're going to say. The prosecutors told you that's what they're going to say. But ladies and gentlemen, I want you to pay attention in particular to part of the defense evidence in this case. And the defense evidence in this case, a big part of the defense evidence in this case is what's called cross-examination. That is, the prosecutor gets to go first because that's the rules. So the prosecutor puts these witnesses on, and after they testify, I have the chance to ask some questions. And I want you to pay close attention when you learn that David Bo Burns isn't a guy who's working at a meatpacking plant. He's working all right as a foot soldier in the El Rucan Street Gang. I want you to listen as you hear how their stories don't match up at all. I want you to listen as I cross-examine Blood. You can find out how he got that particular nickname. I want you to listen carefully because the cross-examination is our evidence. Things you wouldn't know if I didn't stand up there and ask these questions. And then what I'm going to ask you to do is to think about, the judge is going to instruct you about this later, the credibility of these witnesses, whether you can believe them, whether you can trust them, whether it seems likely at all that Steve Shores did this inexplicable killing in front of, steps away from, the headquarters of the El Rucan Street Gang to which the witnesses belong, and Steve does not. There's another person you're going to hear from in this case. And he's a little difficult to understand. His name is Ernest Wells. Mr. Wells was driving the same direction that Steve was riding his bike and heard the shot and saw the man fall. And he went up to where there's a place where you're allowed to make a U-turn around the midway and drove back to try to help the man who fell. He's a little hard to understand because he has a speech impediment. So I'm going to ask you to be really patient and listen carefully because he's going to tell you two very interesting things. Number one, the man he saw over Garrison Hester going through his pocket right after the shooting was dark-skinned. And you can look at Steve and you can see that doesn't describe him. And he was asked to look at a lineup with Steve Shores in it and made no identification. And then I want you to consider who has never been in a lineup. Ladies and gentlemen, when you've heard all the evidence in this case, you will know for a fact that the prosecutor is right. On August 10th, shortly after midnight, Garrison Hester was shot. And the prosecutor is right. On August 10th, shortly after midnight, he was robbed, but the prosecutor is wrong when he says Steve Shores did. The reason I did an opening statement first is I wanted you to have the experience of hearing, thank you, of hearing how much power those first words have. You know, they have so much power. The first thing you hear, what you hear first and what you hear last is so important. I have another reason that I did this particular opening, but I'll tell you about that later. I want to talk to you about how important the opening statement is. okay? And you heard from Robert Hirschhorn yesterday how studies indicate that about 80% of the decision is over at the end of opening statement. If you're not at least even, you are going to lose, and then you have to go do this thing I don't like called a sentencing hearing. I don't like sentencing hearings. I don't want to come back. I want to finish and go home. And you have to be at least even with the prosecution at the end of opening. And so that means you always have to open. You always have to open. You always have to open. Okay? Now, some of you may be saying, well, that's nice, Andrea. I mean, you found an eyewitness who didn't identify, the defendant, and that's real good, so you have, something really good to say. Well, you know what? There's always something really good to say, because there's always something wrong with the prosecution's case, or you can promise a little mystery, or you can tell them to look forward to the cross-examination, or something. But if you don't give them a reason to be here, and you don't give them a reason right away, you've lost. Because first, how many of you presume innocence? I got 2. Yeah. It's counterintuitive. You read Senator so-and-so got indicted for taking a bribe, and you read the newspaper and go, I presume this guy innocent, right? It just isn't the way we think. Okay? It isn't the way we think. We think where there's smoke, there's fire. Police wouldn't arrest somebody unless they had some reason to. And you know what? We think it as much or more than prosecutors in some ways, right? When that file comes across your desk, the 90th burglary you've had to look at in the last couple of weeks, with the TV stacked up by the door and the guy's in there telling you that he had to go take a piss, Am I the only one who had to defend that case? Right? I mean, we don't presume innocence either. And so you really need to understand you've got to counter that energy. And you have to counter it with a story, even if it's a reasonable doubt story as opposed to an affirmative defense kind of story. An opening serves many purposes. One of them is to establish rapport with a jury, and this is particularly important in those jurisdictions where voir dire is severely limited or not allowed by the defense, right? There's plenty of jurisdictions where that's true. Because you want to let them know where you, the human being, are coming from. What's your point of view? Why are we here in the first place? And as an aside, let me tell you one other thing. You cannot sell what you wouldn't buy. You can't do it. You gotta find a place in the case where you can stand firmly on both of your feet and feel good about it. And it may be that, it's a quarter of the case you can talk about. 3/4 you gotta just kind of hope go away in the wishing and hoping category, I mean, I'm not the only one with these files, am I? You come in the morning, they're barking, need to go for a walk, right? I mean, right? We all have these files, right? The 26-page court reported confession, the 5 eyewitnesses who saw him go in there, right? One of them's his cousin. He leaves a palm print on the door in blood. I mean, did it have to be blood? Could we have oil? Perhaps dust would have been good. But you know what happens by the end of the case, right? Defense euphoria takes over. You start to think you have a shot. Another purpose of opening statement is to give the jury a way to hear your evidence, okay? I don't know if some of you noticed this or didn't notice this, but I was telling the jury, that cross-examination is my evidence, right? It's evidence I'm presenting, because otherwise the jury doesn't think you're presenting anything because you didn't call the witnesses, And I believe that juries actually do count up how many witnesses are called and by whom. They do count up how many exhibits there are. Why do you think the prosecution labels each of the 96 hairs with a different number? Okay? They find a clump, we got hair sample number 1, and so that they can, and then they get up to sample and say, we presented 212 exhibits, to prove that he's guilty, and 105 of them are hair and the rest of them are dust or something. I mean, and why do they do that? They do that because juries actually do, in fact, count this stuff. So if you have a cross-examination case, and occasionally that's basically what I have, am I the only person in the room who has basically cross-examination cases? Okay. I mean, I do put on witnesses, I really do, but you need to tell the jury that this is your evidence that you're bringing out, evidence they wouldn't hear without you. This is particularly important when you're dealing with a snitch, federal defender here. Do you have a case without a snitch? The U.S. Attorney's Office, also known as Snitches Are Us, Meaning, they can have the damn thing on videotape. They still turn somebody because they just don't feel right, unless they do. So you want to explain what the cross-examination is going to be. Okay. For example, you ever had a client who sort of decided he was going to help his case just a little bit, and they kind of suborn a little, slightly perjurious testimony, and you ever have them do it in handwriting, leaving their fingerprints on it? So annoying, But anyway, and so you're going to talk about this guy, right? And he's going to testify against your client. He's going to say he perjury was sworn by him. And they've cut him a deal, right? He's charged with a child molest, minimum 6 years. They're going to drop it down to an attempt child molest and give him 5, okay, for him to testify. And so you need to explain what that means and why that's important and why they should pay attention to it in the opening statement. That doesn't mean you have to explain everything about it, but you see, what happens to us is we learn this language, right? We're weird. We tell autopsy jokes, But you can't explain this to normal people. And, and so we understand what the deal means to credibility, but jurors do not. So you need to, if that's your case, you need to lay the foundation, okay? This is especially important if you're attacking the sufficiency of the evidence rather than presenting an affirmative defense, okay? What's another purpose of opening statements? Well, take the wind out of the prosecution's sail. Now, I know we've got people from all different jurisdictions around here, so I want to just check and make sure that I understand your evidence law as well as I do both Michigan and Illinois these days, which is the number one rule of evidence is, does the prosecutor need it? Yes, it's coming in. Is that the rule you have? Right. The second rule is the one that saves me. Is it interesting? Then it might come in, Isn't that the one that saves you? You can kind of interest the judge and they keep him awake or something, or put him to sleep. That's good too. I like sleeping judges. Just leave me alone. So let's say you've got a problem fact. Example, trying a murder case. My client's charged with shooting a woman and leaving in her field near a housing project. Her body isn't discovered for several days, and by the time it is, it has been partially eaten by rats. These pictures are bad even by my jaded standards, little green skin, little teeth marks, lovely. And, my theory is, hey, what Ben and his friends did to her later has absolutely nothing to do with the case, right? My client shot her, or he did, And so I moved to exclude it as highly prejudicial and irrelevant, and of course the number one rule kicks in, and it's coming in, right? I know it's coming in. I know it's coming in. So what do? In opening statement, you talk about this horrifying evidence, right? Because you want to get rid of it. You want to have it not be what convicts your client. And in that opening statement, it was probably, a half-hour opening statement, something like that. Probably 10 minutes of it was on these pictures. And I explained how the prosecution, last thing in the world they want to do, of course, is inflame your passions and get you upset. I love doing that to them, But they have this duty, the poor things. They got to prove that she was alive, and they got to prove that she's dead, and they're going to show you these pictures. But they really don't want to, They're going to make you sick. They made me sick. They're going to make you throw up. You're going to be horrified. I know you are, and all the rest of that. But they got to do it, and I hope you're prepared to deal with it. And actually, it doesn't have that much to do with the case, but unfortunately, they got to show you the dead body, and on and on and on and on. They're squirming on having a good time, okay? Then, when the evidence technician testifies, I raise my hand and said, Judge, I have no objection to the jury seeing it now. Why? I preserved the objection already, right? Filed my motion. Figure I should have them throw up now rather than during my closing argument, which is not when I want them throwing up, And so what's the prosecutor going to do? Say, nope, I want to save them so they'll throw up later. So out they go, and they look at him. The jury's looking at him. They're looking at me. They're disappointed. They've seen Chainsaw Massacre 47. This is nothing, right? Where are the special effects, So what I'm saying is you can take that bad fact, that ugly fact that, that's the stuff that convicts our clients a lot of the time, right? They don't have that much evidence. They just got a really bad crime. And you can do it so that it becomes less important in the case, and the jury just, tells me nicely after they convict my client, it's involuntary. That was a very nice win. Tell me afterwards that maybe I should consider another line of work if I'm so squeamish. You might be right. So, what about the structure of the opening statement? Well, I'm going to tell you what, your English teacher told you. Tell them what you're going to tell them, and then tell them what you told them. That's how people remember things, okay? You want to speak in paragraphs that have topic sentences. Let me introduce you to the neighborhood at 39th and Drexel, and then tell them all about it. Why? So the jury can follow you. And because jurors hear in peaks, they don't hear every word. You don't hear every word, and we like words. We're more word-oriented than most people, you know. What about length? Okay. That varies, of course. How long was the opening I gave? 5 minutes? 8? Huh? About 5 or 8 minutes? Was it long enough? Did you get the idea why you ought to vote not guilty? Yeah, it was long enough. But there are other cases that take a lot longer. For example, I represented a fellow who was a little upset about his divorce, and he, God's law was being violated, and it was being violated by the divorce judge, so he shot the judge and his wife's attorney in open court in front of 27 eyewitnesses. Reasonable doubt was not the defense. And that opening statement was an hour and 20 minutes long because I needed to tell his entire life story to set up the insanity defense, which it hopefully and did set up the no death verdict later. Okay, so you can do something as short or as 5 or 6 minutes, depending on how quickly you can tell the story thoroughly enough that your jury understands what the case is about, but you don't want to get bogged down in so many details that it's boring. You know, I always think there ought to be an objection called boring, especially during chain evidence. Don't you hate chain evidence? And what did you do? I marked it with my initials on this special tape, Scotch tape. Could we, give me a break? Scotch tape, and that's the way, objection, boring. Okay, so that's one of the problems. The other thing is, of course, you don't want to promise something you can't deliver. You don't want to promise so many details that you get it's not pleasant to have your opening statement fed back to you later. It's very unpleasant, okay? You want to have some symmetry in the opening statement, right? You want it to feel like it begins and it ends. It feels like a story, that the music ought to be coming up, which actually I've always wanted. Would you like a music with your opening statement? Or closing argument, the violins swell, the lights go down except on you. So far, haven't been able to get any. Now, I want to ask a question out here. How many of you were listening to me and saying, Lyon, you're arguing the case. You can't argue the case in opening statement. How many of you are saying that? You're goddamn right I was arguing the case. But there was no sentence in front of which I could not say, the evidence will show. Okay? Now, you can always tell when I'm getting close to the line, right? Because I say the evidence will show. Which puts the judge to sleep, which is like I like them, because they never give you any calls, right? These judges give you, they give you motions, they grant stuff, right? They don't grant stuff. Do they, where you live? They don't grant anything. So preferably they should balance their checkbook or something and leave me alone. Let me try my case, okay? And that's the point. You need to be able to say that. And if you get an objection, counsel is arguing, you need to honestly be able to say, Your Honor, the evidence will show that they were gang members. And the evidence will show that this gang dominated that neighborhood. You need to be able to say that. And that's kind of the sifter, that you sift out the things that are pure argument and inference. If it's an inference, you can't say it. Okay? You want to tell a story, you want to paint a picture, you want to make it live. And that means listening to your client's way of talking about the case. I'll give you an example. Try a case, rape case, consent defense. There are 3 defendants. I'm representing this one guy. His name's Joe Cologne, okay? And I actually have pretty decent evidence, unlike just, she wanted it, which is, not that great always, which is that my 3 guys meet the 3 to soon be complaining witnesses in a donut shop about 4 o'clock in the morning on the near north side of Chicago, not too far from the Cabrini Green housing projects, which will be destroyed as soon as the mayor can figure out how to do it politically, because the property's worth too much to let poor people live there anymore. So, anyway, they meet him there, and the guy that runs the donut shop remembers that they meet and they start talking and flirting, whatever, and they leave arm in arm. This is pretty good evidence. You don't usually have this, And then they go back to one of their apartments at Cabrini Green where either sex or rape occurs, depending on how you view these things. So my client, who happened to be a client on bond, which, I can sort of count them on one hand. Do you have a lot of pretrial release on violent crimes? Anyway, happened to be a client on bond, took me to sort of show me around the area, right? Where they park their car, the little gangway that you go in to go to the elevator that takes you upstairs, show me the apartment, etc. So we're parking the car and we get out and he's explaining how everything's going on, and he looks at me and goes, Miss Lyon, he says, I can't believe that they're saying that I raped her. He says, we didn't use no force. Now I admit we used trickeration. Do you like that, trickeration? I'm not going to tell him how to say it right. Trickeration sounds true. Trickeration sounds real. Trickeration is the defense. Okay? It is. It's the defense. And that's what I'm talking about. You need to listen to the world of the case and not try to change it into a lawyer world. If you're going to do any changing, the changing ought to be to a TV world. Have you noticed, like, when you watch television now, like if Marianne and I are having a conversation, they'll have the camera here, and then it, like, jumps to behind her, and then jumps over here. You notice that? How that happens? You know why? Because the average attention span of the American public is 17 seconds. If they don't change the angle, people change the channel. This is not encouraging for those of us who, are not that quick. So you need to try to make it live. You've heard this before, but I'll repeat it. Use of threes. I'll fight them on the land, fight them in the sea, fight them in the air, whatever, how that went. You notice how all your crazy clients, when they go to the door, they got to, like, turn around 3 times before they can go out. I don't know why it worked, but it does. The prosecutor was right, he was shot. The prosecutor was right, he was robbed. The prosecutor was wrong, it wasn't Steve. You want to use threes as much as you can because people remember them better. And you'd like to have your opening statement framing the way that they think about the case. Frankly, I'd like to have the opening statement be where they vote before all that evidence comes in. But so far I haven't won that motion. Michael acted out of fear and panic in defense of his life. Okay? Which means that when you're talking about your theory of the case, you need to get from the theory of the case to a theme or a slogan. Okay? Not, the simple ones, but the more complicated ones. So let me take you through what I mean so that you can boil it down. All right? I'm representing a fellow charged with a rape murder. My client, I had a lot of crimes in August, come to think of it. It's a warm August night in Chicago, and my client lives at 87th and Racine at the time, which is 87th runs east and west, Racine runs north and south, and right there is where there's a train track that goes through, and there's kind of like a hump in the street a little bit. He lives on the southeast corner with his mom, and he's out doing what anybody might happen to be doing on a warm summer night, smoking a joint. So he's hanging around there, and he notices coming down the street, on the same side of the street, but across 87th, a couple, a man and a woman. And he can't tell if they're actually having a friendly walk or not because the man's arm is kind of around the woman's neck, and he doesn't know if this is like love or something else. So he's just kind of watching, and he sees them walk down a gangway to an alley, the alley behind there, east, right? So he doesn't have anything better to do, and he's, on the corner lot. So he walks back, and he looks down the alley, and a few minutes later, according to him, the man comes out running out of the alley, minus the woman. Not having anything better to do, he gets a couple of his thug friends. They drive down the alley because it's absolutely dark, pitch black dark down that alley. They drive down the alley. They find a garage door that's halfway open. In it, lying naked on a piece of plywood, is a woman who's dead with an obvious footprint right here. Okay? He looks at her, and she looks familiar. She looks like a neighbor's relative or something. He's pretty sure he's seen her over at the neighbor's across the street. So he goes to the neighbors across the street, knocks on the door, tells them what he finds, tells them to call the police. Clearly the actions of a guilty man. Because the police immediately arrest him. Okay? And they shake him around for a while. They let him go. They pick him up. They let him go. They search his house. They take his clothes. They let him go. And then the case kind of peters around for a few months. And then New Year's Eve comes, and for reasons Eric never adequately explained to me, he decides he needed a 1966 Cadillac, so he stole one. So he's driving around the next day, and it's on the hot sheets, and some cops see it, and they, put on the sirens, and so he drives down another alley that ends in a T, kind of jumps the curb, runs out, and is arrested. Okay? He's arrested and taken to the 18th Police District, from where he then goes to Area 2 Violent Crimes. Now, for those of you who know nothing about Chicago, that is the home of the School of Torture under Commander Burge. And when I say torture, I mean, electrodes for genitals in the ears. I mean, plastic bags so people pass out. And I don't mean 50 years ago. I mean, recently. Okay? So that's where he ends up. And the interesting thing is no one will admit picking him up from the 18th District, and no one will admit bringing him back. But as soon as he gets back, God bless him, he says to the lockup keeper, "They beat me and forced me to confess." And he has truncheon marks. Okay? Those double parallel lines you get from a baton on his chest and on his back. In fact, he's got a minor cracked rib right here, just a hairline fracture. And for some reason, the lockup keeper reports it. Normally, I hear this 6-7 months into representation. Am I the only one this happens to? Okay, so I file a motion to suppress, and in my jurisdiction, there's this asterisk on the Constitution that says all motions to suppress will be right. Okay, we all work in the same place. And, if you read the asterisk of the Constitution, it says, except in a serious case in an election year or if there's press, right? Right. Okay, so it's denied. But what is the state's explanation for the truncheon marks? Well, remember the car chase? See? The car chase actually was at 40 miles an hour. You jump the curb and hit a tree, and you know those old Cadillacs, they leave truncheon marks on your chest and your back. That's their explanation. So then you investigate that, right? Go to the pound where they took the car. No damage to the car. Go to the neighborhood. No damage to the tree. See? All right, so now what's the theory of the case? A false forced confession, right? That's the theory of the case. But how do I package it so I can talk about all this stuff quickly to the jury right away? Okay? Ladies and gentlemen of the jury, this is a case about a false and forced confession. It's about a case about the police taking the easy way out and taking the square peg of the immutable, unchangeable physical evidence and forcing it into the round hole of a tortured confession. Do you see what I mean? You want to be able to say in a quick way that has a sort of slogan or theme or song-like or play-like feeling why it is you ought to vote not guilty. Okay? You want to tell the jury right away why your client isn't guilty or isn't guilty of the offense if you're going for a lesser included. Okay? Don't introduce yourself. After you win, give them your card. Okay? Who cares what your name is? I mean, you care, but, forget it. Okay? Tell them right away. This is a case about an innocent man. Tell them right away, because that's when you have the most attention. And most of the reason that we do that stuff when we start to talk is because we're nervous. I mean, am I the only one that's nervous? You're nervous. And so you want to fill it up with stuff you know how to say. So, Your Honor, members of the prosecution, ladies and gentlemen, thank you so much for being here. Really appreciate it. And what are you saying that for? Actually, you don't appreciate it. You really wish they dismissed the case so you, could go do something else, right? And don't say that, and just filler. If what you need is time to work off nervousness, I suggest you do this. Breathe. That's what I did. Did you notice before I started? I took a couple of deep breaths. First of all, that means I'm going to place my voice a little louder, which is good. Secondly, the jury breathes too. They don't mind if you breathe. Breathing's okay. Thirdly, there's some silence there, which means that there's real attention on those first words you speak. Right? Real attention. So you want to make sure that you do that. Primacy and immediacy, theme and slogan, come back to it as often as you possibly can. You do want to explain the process of the trial. Now, I don't mean first witness A will testify, then witness B will testify. Or please promise me, swear to me, no jigsaw puzzle covers? Huh? No road maps? Please? Okay? That's boring. Objection, boring. You can all say objection, boring. It's really boring. Let the prosecutors do that stuff. You don't want to do that stuff, right? Do you love that? I mean, but you need to tell them that the prosecutor gets to go first, particularly if your case is a cross-examination case, or if your case is all going to be your case that you put on. Those are the rules, and you're just obeying them. And then I want to tell you one other thing, okay? Well, actually, before I do that, please don't tell your jury that the opening statement isn't evidence, okay? Hi, my name's Andrea Line, and I'm actually an idiot, so don't listen to a thing I have to say. Huh? Don't do that. Don't tell them it's not evidence. First of all, I'm happy if they think it is evidence. I'd be happy if they voted right then. Secondly, the judge has already done that. Hopefully, it's been one statement ago. Don't tell them it's not evidence. Just start in. Don't worry about that. Judge is going to explain all this. And you want to explain about discovery and investigation, and here's why. Tried an identification case. Marianne, I was brilliant. I did this great cross-examination. I showed the lighting conditions. I created a little model. I was great. I was in there, how the blood's in the water, it was just great. And then this jury, this stupid jury, how what happens next, right? Convicts my client. Can't believe it. I'm horrified. And they were out like 8 or 9 hours, I was like, oh man, I don't want this moral victory stuff. I have to go to a sentencing hearing, So I go back, I talk to the jury, and I say, what happened? I was brilliant. I should have won. What happened? I didn't say it quite, but, and the jurors say, you had us with you. There's a real problem with opportunity to observe, and the lineup didn't seem too fair, and there was all this suggestion, reassurance stuff. We were with you, but you see, the problem we had was you knew so much about the case, we figured your defendant had to have been there to tell you. So please tell them there's a thing called discovery and you investigate, okay? Please tell them. Nobody should, learn that way. You want to be honest. Don't promise what you're not sure about delivering, okay? And of course, hold back some details. Give them something to look forward to, ladies and gentlemen. Wait till you hear what Roger Haas does for a living. Give them a little mystery, teaser like they do at the news. Tell them, news at 11, okay? If your defense is they don't have it, okay? They can't prove it beyond a reasonable doubt. How does a jury hear that if you say they can't prove their case beyond a reasonable doubt? Yeah, he's guilty, but can't prove it. That's how it's heard. And so you need to say it in a different way. You need to say it affirmatively. You need to say, this is the wrong person. This crime never occurred. And we're going to show it through cross-examination. You need to say it in an affirmative way, not in a defensive way. If you're defending, you're already losing, right? You're already losing, okay? I'm not suggesting, and I don't want anyone to hear me as suggesting, taking on the burden of proof, okay? Don't say, we will prove to you that he's innocent. Just say that he is, if that's the way you're going to go, okay? But I sure think that the burden of proof and $1.50 basically will get you on the bus, okay? And other people may feel differently. I don't think I've mentioned reasonable doubt in a closing argument in a decade. I just don't think it sells, or at least it doesn't sell when I speak it. That may be different for different people. You want to paint a picture, who is everybody, like actors, place, person, time, what happened. And you want to think of good opening lines, good hooks, okay? I'll give you a couple of examples. Ladies and gentlemen, on the night, this is a November murder, good. On the night of November 22nd, two men ran out of an alley. Both were armed, and both shot Mr. Herrera 13 times. And then they ran. And ladies and gentlemen, one of them is still running. Okay? False and forced confession, we've already talked about. Insanity. Remember my client, the one who didn't like his divorce proceedings? That guy? Okay? Ladies and gentlemen, you may think that you're about to look into the mind of a criminal, but you're not. You may think you're about to look into the mind of a murderer, but you're not. What we're going to do in this trial is look into the mind of a man who once was brave, who once was strong, who once was healthy, but he isn't anymore. Battered woman case. Ladies and gentlemen, I'd like to introduce you to Frances Roberts, and I'd like you to take a look at her face. The prosecutor talked to you a little while ago about a road map. I'd like you to look at the map of abuse on her face. See that mark right there? That's where he put a cigar out on her face. And the cut right here, Frances, can you turn your head? That's where he used a broken bottle to try to kill her. That's the road map I want you to pay attention to, ladies and gentlemen. That was the last time I heard for a long time from a Cook County prosecutor the road map opening. A good opening tells a story. And what are the elements of a story? You have to have some content helpful, a theme or a slogan, good structure, tell them what you're going to tell them what you told them, use of threes. It needs to be absorbing and interesting. You need to set the scene. I like to think of the opening statement as the credits section of the movie. In the beginning, when you hear do, 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 do you think it's going to be like a comedy? No, you already know someone's going to eat someone and someone's going to die real quick in the movie, right? That's part of what you're trying to do, so that you, for example, if you have a forced confession case, you want to set the scene of the interrogation room. I want to take you up the metal stairs and into a cinder block room that's painted a bilious green. I want you to look with me at the ring that's on the wall, that's made of metal, where they cuff a suspect and leave him dangling for hours. You want to set the scene. You want people to understand, as I hope I was able to convey, what that neighborhood was like at 39th and Drexel and how dangerous it is and why people don't talk. You want to introduce the characters. Now, some of you may say, well, how dramatic should you be in opening statement, particularly watching me, which I occasionally get accused of being slightly melodramatic. And, just because I did a closing argument lying on the floor, And it was an accident, but I figured I'd stay there. I got there. Anyway, you need to leave yourself someplace to go. You can't have everything packed, all your emotions packed into the opening statement. Or else what are you going to do, scream at the end? You have to give yourself someplace to go. You need to be persuaded yourself because, of course, you can't sell what you wouldn't buy. And you need to be persuasive, but you've got to give yourself someplace to build up to. So make sure that you don't put everything you have in the opening statement so there's nothing left anymore. You don't want to do that. Really, what's a lawsuit all about anyway? Perspective. Right? It's how you see it. How many of you have ever tried to drive a car in a crowded, big city downtown in rush hour? Huh? What exactly are these pedestrians up to? Huh? They get in the crosswalk and have a tea party, right? They want to exchange phone numbers. You sit 4 lights waiting to turn right. Now, how many of you have ever tried to walk in a downtown area and during rush hour? What, the taxis, they aim for your legs? Huh? It's a matter of where you stand, isn't it? It's really how you see it. It's your perspective. That's what matters. How you see it is what matters, okay? And you need to try to change the perspective of the case. I'll give you an example. This is in an opening statement at a penalty phase, okay? I had a client who got convicted of a double homicide. I had a couple problems with the file. He was an enforcer for a gang. This was a battle over drug turf. There were 2 eyewitnesses who identified him. He had a prior murder. When he was 15, he didn't do the shooting, but he was pretty accountable. He handed the gun and said, shoot the motherfucker, which is, not that good. He got a sentence as an adult at 15 of 20 years. He did 19 of the 20 years. You have to work hard to lose that much good time. Over 120 tickets, couple for stabbing a guard, stabbing. You get the idea, right? Did I mention after he got out on parole, there was a couple of weapons violations for transporting weapons across state lines. He was doing 20 years federal time for that. I don't know, I think I left out a couple things, but you get the idea, okay? And so here's this jury that has come together, right? And they've convicted my client. They've come together and they, and now the prosecutor gets to tell them all about the record because, of course, I did not put my client anywhere near the stand. He'd been locked up for so long, not only was, there's a small problem with provable to deal with, he'd been locked up for so long that he shouted all the time because he didn't have good hearing anymore. So he'd say, oh, the motherfucker, this is not so good, Did I mention during the trial, the prosecutor had a sister crying, and he says, he got up and said, fuck these honky motherfuckers, don't beg for my life, fuck all of them, There's a few problems with the file. And so I need to change the perspective, right? This is not good going into this death penalty part of things. Ladies and gentlemen of the jury, what the prosecutor's told you is true. It is. My client was convicted of murder when he was 15. He was accountable, but he was very accountable. He was sentenced to prison for 20 years, and he did 19 years, and he did all the things the prosecutor told you about while he was there. He did. But let me tell you something you didn't know. Let me tell you how he got in the game. See, Robert lived in a house where there was quite a bit of violence. His father against his mother, and he's a pretty big man now, but he was a scrawny kid. He couldn't really do much against his dad, and he began not coming home shortly after his father eviscerated his mother in front of him. That means he cut open her stomach and pulled her intestine out and laid it on a table. She lived, I'm not really sure exactly how she lived, but she did. And he just began not coming home. He couldn't bear it. And he'd hang out on the street, and the gang tried to recruit him, and he resisted. They broke his arm. You'll hear evidence about that. And then he joined. And at 15, he participated in this murder. But what the prosecutor didn't tell you is this. See, he was 15. He was 5'9", and he weighed 127 pounds. And they sent him to Statesville Prison. And they put him on a tier with lifers, adult lifers. And he was the only African American on the tier. And he was raped. The reason we know that is finally one day he couldn't come to the count because he was sitting in a cell in a pool of his own blood. He learned to fight. You know what I mean? You can change the perspective. You can. You just have to find out how. You have to do the investigation. You have to think about it and find out how. You want to paint a picture of the story of the case and let it come from the inside persuaded self. You want to give the jury permission to feel what they need to feel to vote your way, because that is how juries vote. They vote with their heart or their stomach or whatever part of their anatomy they identify with, and they justify it later. There is no other explanation for elections otherwise, right? It's not the facts that count. It's what people feel about the facts that count. I told you at the beginning that I did the opening statement, the little opening statement for you for two reasons. One, I wanted you to have the experience of hearing it. And this is the other reason. I've been waiting 15 years to do that one. I represented this fellow, Steve Shores, and he was innocent, and I really don't like innocent clients. They are horrible because you break your heart over it. In 1982, I tried his case. And I listened to more experienced lawyers than me. I said, this is a good case. You got all kinds of impeachment, there are bad witnesses. You take your good case to the judge. And I went through it. He was convicted. I felt responsible. I wrote the appeal myself at night, And I lost the appeal 2-1 with a 60-page dissent. I went to federal court. I lost. I went to the Seventh Circuit. I lost. In the meantime, there was a corroborating witness, and I ran into somebody who said that she'd been paid, and I filed a state post-conviction based on that, and I ran that all the way through. I won for a brief moment in federal habeas, and maybe some of you saw this on 60 Minutes. It was on 60 Minutes some time ago. For a brief moment, but the Seventh Circuit, they, had no truck with that, and I lost again. And the whole time, the prosecutors maintained that Bowe and Burns were no longer members of the El Rupins, Burns and Bland, that they were minor players at the fringes, that they, all that they maintained this the whole time, the lying people. Because the third time round, this is what I found out. See, there was this big prosecution of the El Rupin Street Gang, and a friend of mine, a faculty member here, Mary Ann Jackson, was representing one of them, and she mentioned that there was a bunch of notes that were taken of David Burns in this federal prosecution, so she gave them to me. And from those notes, I found out that Burns and Bland weren't minor players, that they were murderers, that they had committed another murder and framed a different person 6 months before they framed Steve for this one. I found out later on, although the prosecutor lied about it, I found out that David Burns had testified admitting to these murders in open court, in federal court, not once, not twice, but 3 times, and this was never turned over to me. I found out that there was a note taken by one of the investigating federal officers in which Bland confessed to this murder. To this murder. I guess there's something to be said for being stubborn. So, last fall, I've been doing this case for forever, and I have a special line item on my taxes where I take off for, representing Steve Shores, phone calls and everything else. And last fall, I finally got the prosecutors to do the right thing. A combination of fear and appealing to their better side, whatever that might be. And I got a call at home on a Friday. It was Steve. He says, Miss Lyons, Andrea, it's Steve. And guess what? I'm not calling Colette. Says I'm home. And I'm home for exactly one reason. Because you listen to me. I beg your pardon. See, there are a lot of Steve Shores in this world. And they need us. They need us not to give up. They need us to learn how to fight. They need us to believe. They need us to care whether it's right or wrong. They need us. They need all of us.